Welcome. We'll go ahead and get started. I'm Claire Kelly, the council member for the 1st Ward, and I'm here with Council Member Revelle from the 7th Ward also. And Council Member Suffredin from the 6th Ward is also sponsoring an event that couldn't be here this evening. So thank you all for coming here this evening to discuss this very important topic for Evanston of tax-exempt property. As I'm sure everyone's aware, we have a disproportionately high percent of our property is tax-exempt, and that has a direct impact on everybody in terms of property taxes. So I'm so pleased and grateful that we have with us this evening Christina Lynch, the Director of Legal at the Cook County Assessor's Office. Christina is focused, she's a specialist on tax-exempt property. She focuses on special properties, FOIA matters. She serves as the Ethics Officer at the Cook County Assessor's Office. Prior to joining the Assessor's Office, she served as Ethics Manager and State Staff Attorney to the Cook County Clerk, and she managed lobby registrations, electoral board operations, and presided as hearing officer and administered the vote by mail program. We also have with us Nicole Jardine. She's the Chief Data Officer, and back here. Thank you for coming this evening. And also Angelina Romero, the Chief Communications Officer with us from the Cook County Assessor's Office. So I'm going to go ahead and pass this to Christina Lynch to begin a discussion and begin a presentation about tax-exempt property. She will then stop at the end of the presentation and allow for time for questions and answers. So without further ado, thank you so much for being here this evening.
Thank you, Councilwoman. Thank you so much. I'm so glad everyone could be here tonight and your interest in the tax-exempt process here in Cook County, or really in the state of Illinois, but specifically in Cook. I will just say that Evanston holds a special place in my heart just because I grew up in the North Shore, and I used to work in Evanston for many years at a restaurant, waiting tables and sometimes taking cash at a place called the Sherman Restaurant. I used to be at the corner of Clark and Sherman, but it's not there anymore. But anyway, so I grew up around here, and I do love the area, and so it's always fun to be back. And I'm here to talk about non-homestead property tax exemptions. Why are they called non-homestead? Well, they're non-homestead versus homestead. The homestead exemptions are the ones like the senior citizen exemption, your homestead, your homeowner's exemption, or a disabled veteran's exemption that you get on the property. These are non-homestead exemptions are the ones that apply to various specific types of properties that go through a process to become exempt from taxation. And I'm going to go through how that works. So the first thing we're going to start talking about are exemptions and what those qualifying properties are. There are several in the property tax code. I'm going to really just go through the properties that we see that most commonly get property tax exemptions. There are just nuances in the law. I'm sure, like most laws, there's little nuances throughout the property tax code. So again, these are just like the bigger types of properties that qualify for property tax exemptions. Property tax exemptions, or the non-homestead kind, you have to have the two components, ownership and use. You have to both own the property and use it for the specific type of exempt purposes that are allowed under the code. So if you don't own it and use it for those purposes, most likely, I presume, and because the Illinois Department of Revenue grants these exemptions, they're going to be the ones that decide on whether or not you qualify. But usually those are the things that, those are the very primary requirements that you have to have first. Do you want to? Yep. So, religious institutions are one of the types of properties that can get property tax exemption. They have to be exclusively used for the purposes that are set forth in the property tax code. For religious purposes, it can be school and religious purposes, but also parsonages, convents, and monasteries that are used for exclusively religious purposes can also get exemption from taxation when the person who's performing those religious services is as a condition of their employment and resides there. So that's one. Then there's government property. Government property includes anything owned by the United States government, any state government, any of the branches, any of the agencies of the state government, and then of course local governments like the city of Evanston owns multiple properties that very likely exempt from taxation. Other taxing districts own exempt properties. County as well, I should have mentioned. County is another one. All municipalities, counties, and state agencies are exempt from taxation if the Illinois Department of Revenue says that they are. So they still do have to go through that process of applying for the exemption and getting the state to approve it. And then libraries and fire protection districts are also taxing bodies that may qualify for exemption from taxation. Charitable organizations. Charitable organizations, beneficent and not-for-profit organizations, all free public libraries, historical societies, when exclusively used for charitable purposes, may qualify for a tax exemption. And then there's hospitals, which is a unique part of the property tax code. Originally, hospitals were qualified for property tax exemptions under the charitable purposes provisions of the property tax code, and then there was a big case that went to the Illinois Supreme Court in, I want to say 2011, and things kind of changed. There were a lot of issues surrounding whether or not hospitals that were getting exemptions were truly providing charity care to qualify for charitable purposes exemption. And so then it went to the Supreme Court, and then of course the legislature decided that they were going to carve out a very specific exemption just for hospitals. And it's a very, very long, lengthy, detailed, nuanced provision that the legislature wrote back in 2012 for hospitals. But basically, not-for-profit hospitals, if they're licensed under the Hospital Licensing Act, they can qualify for a charitable exemption if the value of the services or activities, such as charity care, for that hospital year equals or exceeds the relevant hospital entity's estimated property tax liability. Who estimates that property tax liability? Under the property tax code, it says that the hospitals get to do that. Yeah. And there's a whole formula that is set out in the property tax code as to how they are to estimate their property tax liability. Next, cemeteries are also exempt from taxation, of course, and then agricultural or horticultural societies are some of the smaller ones that may qualify for exemption. Schools, all public schools tend to qualify for property tax exemptions. If they're leased out with a view to profit, then the leases, we have to look at those leases and see whether whether they're taxable or non-taxable leases. And then there's the charter exemptions. The charter exemptions are unique. It was before the Illinois Constitution of 1870. The General Assembly granted 80 corporate charters to various private educational charitable institutions with specific provisions for property tax exemption, Northwestern University being the most famous one. So the Northwestern University charter exemption exempts all property of any kind belonging to or owned by Northwestern. They have a special exemption, and I'll get into it a little bit more. So there were multiple challenges, of course, to this exemption because it originated prior to the 1870 Constitution. And the Illinois Constitution in 1870 changed that and said, the General Assembly can't grant these types of charitable exemptions anymore. But since they had already granted it to Northwestern, Northwestern got to keep it. Every court challenge that Northwestern has faced since then, they have won. The courts have said that it applies to all property that's acquired before and after the Illinois Constitution of 1870. It also withstood constitutional attack on 14th Amendment equal protection grounds. There were some folks who challenged it, saying that this deprives other colleges and universities that don't have the exemption. It deprives them of equal protection, and the court said, no, sorry, it's constitutional. So, yes, charter exemption does create inequities in the property tax system, pretty big one. And Northwestern, of course, owns a lot of property in Evanston. But it looks, I mean, based on the case law and its history, it looks like it may be here to stay permanently. I don't know. I mean, I don't have the answers, but that's the way it looks based on the case law that's out there. There is some argument to be made that if Northwestern leases out space, and it's a true lease agreement, which I'll get into a little bit more later, which is distinct from a licensing type of use of the property. If they lease that space out and they're deriving income from it, as long as it's used for educational purposes, they will still probably enjoy the benefits of an exemption, of the charter exemption. That seems to be, from the case law, the only exception where if they lease out space and it's not deriving income that is used solely for educational purposes, that it may contravene the original intention of the charter exemption, which was to be for educational purposes. So how are exemptions created? The application process for exemption from taxation actually starts at the Cook County Board of Review. They have filing windows every year. It used to be they only had 2 filing windows each year that lasted about 60 days. With the 2 new commissioners that were recently elected, the board just changed their rules, and they now, or at least last year, this year, had 4 filing windows where they were open at 4 different times during the year to accept exemption applications. When the Board of Review gets those exemption applications, they review them. They make a recommendation to the Illinois Department of Revenue. They send that to the Illinois Department of Revenue, and then the Illinois Department of Revenue is the sole and only authority in the state of Illinois that can say whether or not your property is exempt or not from taxation. The assessor's office does not make those decisions. We apply whatever exemption the Illinois Department of Revenue has granted or not to a property. And IDOR can make, they can make exemptions that are 100% exempt, right? Or they can make partial exemptions. Let's say, for example, let's say somebody like the city of Evanston, say they decided they're going to apply new property, they apply for a particular property to get an exemption from taxation because they own it, but they're leasing out that space to somebody else. They're supposed to disclose to the Illinois Department of Revenue at the time of application that they're leasing this space out, so that the Department of Revenue can then consider, well, whether or not, what they're going to do with this lease. Property owners that don't disclose leases for whatever reason at the time of application, whether because they haven't leased the space out yet and later do, we typically at the assessor's office, when that happens and we find out about it, we'll send somebody out to inspect the property to see, if somebody's using that space for anything other than exempt purposes, and then usually we'll try to somehow get a copy of the lease from them. But the property tax code does require that these properties send us copies of the leases if they haven't. So we don't do any types of audits of any kind to see who's doing what. It's just if we hear word of mouth, sometimes people will call us and say, hey, you know what? That church or that whatever religious institution down there, we think somebody's leasing space out from them and it's not being taxed. And then if we find out about it, that's when we'll send somebody out to determine whether or not we need to assess. And in those instances where they haven't disclosed leases to us, the property tax code does give the assessor discretion to remove the exemption for failure to disclose a lease. It's very limited to really that. Otherwise, the authority to remove an exemption from a property also rests with the Illinois Department of Revenue. So to maintain your exemption, though, do you have a question?
Yeah. Does it make a difference whether, let's say, City of Evanston leases to a nonprofit or to a for-profit?
Any lease, if Evanston leases out to a nonprofit, that nonprofit still has to pay. That we would still consider that a taxable leasehold if it was something that wasn't disclosed to IDOR and IDOR hadn't granted a partial exemption. If they disclose it to us, depending on the terms, we do have to review the terms of every agreement that they're entered into, but most likely it's going to be taxable. The only The provision for charitable organizations in the property tax code does allow charitable organizations who lease out space to other charitable organizations to also maintain the exemption for the leased space. It's the only provision in the property tax code that I'm aware of that allows that to be the case. So, but maintaining an exemption, so every year, all properties with 3 exceptions are required to certify annually with the assessor's office that that there's been no change in ownership and use of that property. We have at the assessor's office an online application for all owners of exempt property to submit their annual affidavit filings with our office. Those affidavits, the system basically allows them to go in. They can pull a list of all of the PINs that are showing in our records as exempt to that agency or that organization. Then they verify it, they submit. If they have any changes in ownership and use, if they've sold one of their PINs to somebody, they should tell us during that period of time. They don't have to tell us at annual affidavit time, but they can. Your owners are allowed to use our online application at any point in time during the year to notify us of a change in ownership or use. And they can upload all of their lease agreements, they can upload any deeds, anything that we need to get copies of. They can use that online application during annual certification time or at any point in time during the year. But annual certification is required under the property tax code. The obligation is on the property owner to certify to us annually every year by January 31st for the prior year, basically. So by January 31st of 2024, the property tax owners, or the owners of exempt parcels in the county are to tell us whether there have been any changes in ownership and use for the 2023 tax year. So that's how that works. And as I mentioned before, that removal of exemptions is really strictly within the authority of the Illinois Department of Revenue, unless, of course, the assessor's office's discretion falls under a failure to certify or a failure to file lease agreements. I will say that there are, in Evanston, I think there are a little over 1,000 exempt properties in Evanston. It's a lot of properties. I think it was 1,048, something like that. And that is exempt properties that are either 100% exempt or are properties that have where we've created leasehold estates, which is where there are leases and we've actually assigned a PIN to those leaseholds. And those are typically created for properties owned by taxing districts or government agencies. We create separate leasehold PINs for those. So that list doesn't include properties that may be partially exempt from taxation because the Illinois Department of Revenue issued a letter that says this PIN is 86% exempt and 14% taxable. So there may very well be other properties that have exemptions on them that are not included in that number that I just gave you. So next, I'm going to go into a little bit more about changes in ownership or use. So when the owner of an exempt property sells or transfers their property to a new owner, that constitutes a change in ownership, triggering removal of an exemption. That is another time where we would remove exemption, but that's because there's been this change of ownership. Change in use. When the owner of an exempt property leases out part or all of their property, it constitutes a change in use, also making the leased space taxable, and that doesn't necessarily mean we remove the exemption, we only remove a portion of it, the portion that's leased out, whatever that space is that's being leased out. Sure. Of course. Yeah. I'm happy to answer whatever. So there are notification obligations that are set out in the property tax code for when there has been a change in use or in ownership. In cases where there's been a change in use or a change in the leasehold estate, it's the obligation of the owner of the exempt property to notify the assessor within 90 days of that change. And in the cases where, in the case where there's been a change or a transfer, same thing. It's a 90-day window. The new owner, the transferee, is required to notify the assessor's office that there's been a change, that they've bought this property from an exempt organization, and then that will trigger us to send somebody out to assess the new owner. There are certainly scenarios where we've had, say, one religious institution sells it to another religious institution, but because exemptions, like I mentioned in the very beginning, are based on ownership and use, we can't just automatically grant that new religious institution an exemption. They have to go back to IDOR and get their own exemption, and then we will apply it. So just because an owner who's probably going to be exempt from taxation buys it from somebody who was previously exempt, doesn't mean they get to carry it over. Every letter that IDOR issues, when I say IDOR, I mean Illinois Department of Revenue. Every letter that they issue very specifically and clearly says the name of the owner that gets that exemption, and then the PIN numbers that are exempt. And it tells you, the year that they approve the exemption, and then it tells you what if it's 100% or however it's split up. And there are some very super unique partial exemption letters that we see from time to time. It'll say 90% exempt, and then the 10% exempt, except for the 565 square feet of the basement the basement unit, or whatever the case may be. There's very strange partial exemptions from time to time that we see that we have to kind of make sense of, but we get a lot. So this brings me to Millennium Park. Hold on, let me see really quick. Yeah, so Millennium Park was a case, an Illinois Supreme Court case. Everybody knows what Millennium Park is, right? If you live in Chicago, you know what Millennium Park is. And Millennium Park Joint Venture LLC entered into an agreement with Chicago Park District, who's really the primary owner of Millennium Park in Chicago. They had entered into a concession permit agreement with the Park District. At the time, Assessor Houlihan viewed that lease, that agreement, that concession permit agreement, viewed it as a taxable leasehold and assessed it. But Millennium Park Joint Venture LLC sued, saying, no, this is a concession agreement, and it is a non-taxable license. The Illinois Supreme Court upheld the circuit and appellate court decisions that both were in favor of the plaintiff, the Millennium Park Joint Venture LLC, that the concession agreement was merely a non-taxable license to use the space. So in so doing, the Supreme Court summarized the criteria that separate license from leases, and I'm going to go through those with you so you can understand the difference between a lease and a license. Thank you. So a license generally provides that a licensee with less rights in the real estate than a lease and is ordinarily revocable at the will of the grantor. The terms will merely confer a privilege to occupy the premises under the owner. And then the lease is, if the terms of a lease agreement or of an agreement give exclusive possession of the premises against all the world, including the owner, it is a lease. Leases will have definite boundaries, a definite term, rent, and definite time and manner of rent payments. When we see agreements, when I review them, I have to review the terms of the agreement to decide whether or not it's actually a license or a lease. I can't just because it says license agreement at the top doesn't mean that it's a license. Depends on what the terms of each agreement is. Just because it says it's a lease agreement doesn't mean that it's true lease. I've seen multiple agreements that are labeled lease agreement, and I read them and I say, well, it's actually a lease. They're just occupying some space, and they have absolutely zero rights to that property under the terms of this lease to do anything other than use it. So it's very dependent on what the terms of the agreement are. Just labeling it one or the other doesn't make it so. And here was one of the big things that I thought was really nice that the Illinois Supreme Court said, was that the principal difference between a lease and a license is that a lease confers the right to exclusively possess and control, whereas a license merely confers a right to use for a specific purpose subject to the licensor's control. it was kind of a nice little easy way to distinguish between the two. And the factors that I look at are, of course, those are the types of things that I'm looking for. So we can stop here and ask questions about exemptions, if you have any that I have not yet answered in full.
In regard to, exemptions and non-for-profit, tax exempt properties, I'm assuming that information is also available to the public if we have a PIN or an address?
If you want to find out if it is exempt?
Yeah, and look at some details of like, are they fully exempt? Is it partial? Like that actually we could find online.
Sure.
Okay.
So if you go to the assessor's website and you know a PIN, or if you know an address, you can even just find something by an address. You can plug it into our little there's a little bar on the home page that you can go down and type in the PIN, or do a click on search by address, and you can find out if you say you pull up a property, if it says when the assessment information comes up, if it says NA not applicable, it's exempt completely. If you want to find out if it's partially exempt, you can usually will want to contact our office and find out. We'd have to tell you because it won't be clear just from looking at the numbers online. Although we do have an open data portal that you can that anybody can access. It will give you access to all of the property tax exempt parcels, but that's just the 100% exempt though, no? Or is it even the partial? That's what I thought. So the partial exempt, you'll have to contact either me or, if you were able to get to anyone else in the office, but I do a lot of that.
Thank you.
Yeah.
I'll try not to monopolize your time. But I have a lot of questions
Please
about
do.
Northwestern. You mentioned the charter, and I've looked at the charter many, many times. So the charter, in the very first charter, 1851, it says what you said, for educational purposes only. That's what their property is supposed to be used for. And that same first charter, before the amendments, it says at the very end that, should the Board of Trustees violate the charter's regulations, blah, 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 they could be taken to court and the circuit court could remove their charter. That was in 1851. The First Amendment is when it included the tax-free, anything Northwestern property that they own is tax-free forever. So I guess my question is, have you come up against that before, where someone has challenged their charter status in circuit court because they continue to violate their the agreements that are stipulated in the charter?
Our office specifically, we haven't been involved in any of those cases that I'm aware of. There have been cases that have challenged the charter, and I haven't found any cases where Northwestern lost.
Well, they basically had to sue themselves in the 70s
Yeah.
to get the piece of the charter that talked about within 4 mile radius, they couldn't purchase or have access to alcohol. Well, they won that on appeal because prohibition had changed.
Mm-hmm.
But I'm not aware of any other big challenges in court. Like I said, they brought that on themselves, the court challenge. So I guess the other question would be, my interest in this came through their current activities regarding Ryan Field, wanting to have the city approve a text amendment that would allow them commercial, it doesn't say that, but in reality, they would be allowed to have commercial activities such as concerts, with big name stars coming in to Evanston. They'd lease space presumably to these groups. They would profit from the sales that go on. So in my mind, that's a change of use and should be taxable. Same thing for other properties they've developed that are either rental properties at very high rental costs or condominiums and other types of businesses that are commercial properties. Are you saying those, if we send you a note, could you look at this property because it looks like it's a commercial use and you would investigate that?
Well, we would review the agreement. Whatever the agreement is that's what we would look at. The Northwestern Charter is broad, the charter exemption.
Well, the charter itself is not very broad. It's a very tight language, but you're saying at some point.
Well, meaning it's broad in the sense that it applies to any property that the university that belongs to it or that it owns.
For educational purposes.
For educational purposes, right. So if they do lease out space, they have to they do have to show that they're leasing it out for educational purposes. And I would imagine if the lease agreements are clear enough that the income that they're deriving is for educational purposes, we have to honor that. But I haven't seen any like that, and there haven't been a lot of issues with that I have seen in the last 5 years come to me.
Right, well, this hasn't been approved yet.
Right.
And we hope it's not going to be approved, but should they have commercial concerts?
Yeah.
People from, I don't know particular group that might come there, but big name performers, international performers come there with full house, 35,000 people, and they would profit from that. Whether they reinvest that somehow in the university is meaningless to me.
Right.
So.
I hear your concern, and I think that Northwestern has a decision to make if they're going to actually make the terms of this agreement into actual lease terms. And basically surrender control of the entire premises to whatever vendors they've entered into agreements to. That's going to be evidence that it's a taxable leasehold. If the university decides that they're going to just license out this space to be used by vendors or organizations or whatever the case may be, or whoever they enter into agreements with, if those are truly strictly licenses that only allow them to occupy that space, those would be non-taxable licenses. Yes. Oh, there's a question back here. Or did I miss somebody else first? Oh, sorry. There's an order. Sorry. Yes.
Hi. So just to build off the previous question,
okay.
And to kind of clarify the case that you brought up previously with Millennium Park, when it is a license, even if it is maybe a for-profit, like a company coming in for-profit on a license, that, because it is not a lease, is still an exempt use. Is that correct?
Right. So if it's a license and they're just occupying the space and don't have any real, like they can't assign it, they have no rights to do anything with the space other than to use it. I mean, they may still pay, the landlord that is the exempt owner of the property some form of rental payment, but that alone doesn't make it a lease agreement that's taxable. It just means that they're getting money and letting somebody use their space. That's, yeah.
Thanks for coming. I did have a few more questions around this. So one is, I know you said there's like 1,000 potentially tax exempt properties in Evanston.
Yeah.
Is there, where would you point us to get a breakdown of, do those records exist? Maybe not at the assessor's office, maybe at the treasurer's office, of who owns all those tax exempt properties.
So we do have the Cook County Open Data Portal has data for all of the various agencies. And there's ones also for property taxation, and we have what's called the 2023 the Cook County Assessor's Open Data Refresh. And on there, we just actually launched earlier this year a data set that includes all of the exempt parcels, and you can filter out that data by township, by year, and get a list of all the properties in Evanston just in a few clicks.
And who owns them?
Right,
Okay.
right.
And then in terms of the requirement that a property owner, when there's a change of use, or even every year, they're supposed to, say about these leases.
Right.
You may not know off the top of your head, but does Northwestern do that when there's a change? Are you aware? Do they participate in that process of when there's a?
They're required to.
Yeah.
We do try to track. We do track what we get back. And now that we have this online application, actually, that we just launched at the beginning of this year, it's even easier for us to track who's submitted what.
Yeah.
Now, the obligation is on those owners to submit all of that stuff to us, and we just, we don't have the resources to just to monitor this on a daily basis and make sure everyone's doing what they're supposed to be doing. We do make an effort to get some people to comply if we're able to. If it comes across someone's desk and they say they couldn't find an affidavit, or if we get a FOIA request and I'm like, oh shoot, we don't have that, we need to get that, that may prompt us to say we need to reach out to these people and get their affidavits. It can be a laborious process for some organizations because they, some, like Metropolitan Water Reclamation District, they have something like 2,000 tax exempt parcels, and it takes them forever to upload all of the information that they need to upload from time to time, or check all the pins to make sure that they have everything straight. O'Hare is another one that's really tough. They've got a lot of, they're exempt, but they also have a lot of leaseholds, so many leasehold pins. And it's always changing and evolving, and it's a very difficult process. And then there's University of Illinois has a lot of taxable leaseholds as well. But yeah, so we do try to keep track of the people who are submitting all the annual affidavits. We just can't always kind of hold them to it,
And I just have one more question, and I know you're not, you don't have the encyclopedia in your head of all this information.
I don't, right.
But since you are familiar with Evanston,
Yes.
You mentioned, can you think of it? Is there an example where Northwestern, they lease out the property and then either the leaseholder or Northwestern is paying property taxes on that? Can you think of a single example off the top of your head?
I don't know of one, to be honest with you.
Because I want to point out, that's very unusual for universities, and I know they
is.
point to their charter, but Yale University pays commercial property taxes in addition to payments in lieu of taxes. There's many other universities that actually do. There's University of Chicago apparently too. I don't know all the examples, but there's many out there. But thanks.
There are others, yeah. And I will say that I did mention that there are 3 types of organizations that do not actually have to annually certify with our office. Religious institutions do not have to certify, and unfortunately that is a huge problem. Because they tend to, sometimes properties change hands and then we never know about it because they don't have to tell us. Anyway, so that burial grounds, cemeteries don't have to tell us if there's been a change in ownership and use, and that's probably because I don't think there's going to be a lot of change of hands of cemeteries, right? And then United States property, they don't have to tell us either. So those are the 3 exemptions. Yes.
And again, thank you for coming, but the question is, if you were to assess the Northwestern property, what would it be worth in property taxes?
I can't really answer that question. What I can tell you is that when we do value a leased out space, we calculate the net present value of that leased out space based on the rental payments and the income stream in the future, depending on the term of the lease and the amount of rent. That's how we calculate the net present value of that.
I guess what I'm asking is, if we're talking about
Yep.
Northwestern paying something, it'd be nice to have a number of what they should be paying if they weren't in this charter tax exempt.
Right.
In other words, they should be paying $20 million in property taxes. Well, they're only, that's a benchmark. Well, how much should you be paying in compensation otherwise? I mean, it'd be nice to have that figure. Is there any way to go about it?
You're saying a figure if Northwestern was not exempt, what would their property be worth?
Exactly.
That is the goal. That is the bonus question. That's the million or the $1 billion question, right? The assessor's office does not we do not maintain values on exempt properties. So we don't know what they're worth. There's a lot of properties in Cook County that have been exempt for decades and decades and decades, and we have never had an assessed value on them. There are some jurisdictions in this country where they do keep what some of them call them shadow values, if you will, like it's just a shadow value for property that's actually exempt from taxation, and they'll put on a market value on that property just to have it there, so that if there is ever a change in ownership or use, and I don't know how every jurisdiction works, but just hypothetically speaking here, if there were an exempt or a change of hands or a change in use, they would have a better idea of what that historical market value is of the property in order to come up with a current year market value of the property. So, but we don't do that in Cook County, and we're not required to.
Following up on David's questions, if Northwestern, or let's say some billionaire university like Northwestern, were to be out there buying up property and leasing it, I mean, they make some deal with either a residential property owner or a commercial property owner saying, I want to buy your property, as long as they set some term limit to it, or you can live there forever until you die, and then it becomes our property. If that were happening, how would you view that? So they approach a property owner, they say, I want to buy your property, you can live there forever, but at the end, we own it.
Oh, you mean if there's a deed restriction, for example?
I suppose, yeah. I have to say allegedly, because I don't know this firsthand, but I've heard rumor of this going on.
Or like a ground lease arrangement where the land is exempt, but the improvements are like leased out for like 99 years or something.
Something like that, yeah.
Usually with the ground lease type of arrangement, the land is still exempt to the owner because the owner is usually an exempt entity like Chicago Housing Authority or Cook County Housing Authority. Those usually are where we see ground leases like that you're describing. The improvement is assessed and then the land is exempt. That's how that
So
works
if they buy
usually.
it, regardless of how they buy it, it becomes exempt, is what you're saying.
If their ownership, if the Chicago Housing Authority, whatever they do, they're usually the ones that, like I said, that we see these ground leases on. They own the property, and then they will, they'll enter into these agreements for somebody else to basically use the building that sits on the land, but the land remains exempt to these authorities. Or there's other ones too. I can't think off the top of my head which ones they might be under those types of structures. And then maybe there's deed restrictions too. We do have to follow whatever the deed restrictions might be. Let's say and we do see them, and I see them, I've seen them in Evanston, in fact, in like neighborhoods where there's some, affordable housing that maybe it's naturally occurring affordable housing, and there are deed restrictions on how much that property can be valued at. We do have to follow those types of restrictions because they are legal restrictions.
Right. Okay, so one last question on Northwestern. I heard what you said as far as, no case against them ever being won.
Not that I know of, I only know of the ones that are like actual, like that make their way to the appellate court or the Supreme Court. The ones anything that happens in circuit court, I may not know if there have been other challenges over the years, but the most recent Illinois Supreme Court case in Northwestern, for Northwestern property was from 1972, I think.
So where would one look for those cases? Can you direct us to that?
I can share with Claire some of the citations to those cases if you like. There's the ones that I know of. But yeah, I can share that with her if she wants to share with the residents that are here tonight. Or yeah,
I actually have
unless
I am not as familiar with Evanston, but I am curious city in Northwestern, because I get the feeling that a lot of us don't
That's a
want
complicated
them
question.
to be exempt, so I'm just curious, do they contribute to the city, do they donate things, like what are you, I don't know, what's the relationship with that?
General sense that they often pay more.
But do they donate anything, or do you have a relationship, do they sponsor things? Oh, okay.
Yeah, if that's a major topic of discussion right now, but, yeah.
Yeah. Yeah. So building off of Mike's question about the ground leases, I'm curious if the land underneath were to be exempt, but the improvement, the building on top, was taxable. Who in that instance owes the tax? Is it the property owner, as in the landowner, or is it the person who has the lease for the improvement?
It's the person that has the lease for the improvement space. When there are leaseholds that we create, leasehold pins, those tax bills go to the tenant, not to the owner. Typically, right? Unless there's some weird provision in their lease agreement, which does tend to happen from time to time, but very rarely. The tax bills do go to when the property is 100% exempt and they're leasing out space, it goes to the tenants. If there is a property that is only partially exempt, we can't separately send the tax bill to the tenant. It has to go to the property owner that's exempt, and then they figure out with the tenant how, who's going to pay those property tax bills. So that's how that works.
Hi, thank you for being here. I've got a couple questions. One is on the leasehold pins, where would you ever find that is that also on your data refresh portal?
Well, actually, the list of the tax exempt parcels does have all of the pins that we'll have. You'll see, how your PIN number, the last 4 digits are usually 0 on your home or on most properties. If it's a taxable, if there are leaseholds assigned to a particular tax exempt property, you will see those last 4 digits in the 8000 series.
Oh,
So if the last 4 digits, if you were to pull that list of the tax exempt properties from Evanston, and you see a bunch of pins in there, and some of them have the number 8001, the 8001 is the number that's assigned to the tax exempt part of the property. All of the sequential numbers that follow, 8002, 8003, or 4, are for the tenants that are leasing out space from that tax exempt entity.
okay. So, and then following up on Mike's question on, sometimes it's not just Northwestern, but sometimes people may donate their property to the nonprofit and then live in it. As you said, I do know someone who had done that years ago to Northwestern. Is that whole property then tax exempt from the time it's donated to them? While the person may live another 10 years?
Probably. I couldn't say for sure, but
Okay, so,
most likely, yeah.
all right, and then the last question I have, and I'm sorry, monopolizing this,
No, not at all.
has to do with, so if I'm a church or a hospital or Northwestern, and I have this property and I want to lease it out for something that's totally unrelated to me, but I'm saying that, and my purpose, but I'm saying that I will get a little bit of money for that to help my company. Does that, or my purpose, does that qualify me to be tax exempt? Because I'm not really running the place for a church purpose or a university or a health purpose, but I am generating income, but the real people generating income is the other purpose. Whether or not it's for a casino, like theoretically, if Northwestern wants to do a lot of commercial stuff there, they're not doing educational stuff. If a church, like over in the middle of Evanston, there's an old church that's been basically abandoned, it just sold. But if they wanted to turn that into a casino and had kept this tax, could they do that and say, well, we only need it on Sundays. So the other days of the week, we're just going to run a casino. So that's what I think is kind of screwy, is like to the purpose, and how does one address that?
It's up to the Northwestern and the agreements that they enter into, and then we have to review whatever comes our way and make a decision based on the terms of each agreement. Northwestern can lease out whatever it owns. If it wants to lease it out and enter into contracts or agreements, they can do that, you know, as the owner of the property. I think I understand that to be your question. If it falls within the charter exemption, then it's not taxed. If it falls outside of the charter exemption, then we would assess it. Yeah. I just haven't seen anything like that, honestly, from Northwestern.
So it sounds like it can at times be a fine line between lease, when you're interpreting lease and license.
It sometimes actually can be, yeah. Sometimes I read these and I'm like, oh my God, I got to really make a decision here, you know, and sometimes it is a judgment call because it's not all black and white.
Right, so you know what the rights are of the person. I'm sure the person who licensed, who pays, also has some rights, not just would be different than renting per se.
Yeah, and usually their only rights are just to occupy that space for, you know, like Millennium Park. They occupy the space for, you know, selling food or whatever the case may be. They call them concession agreements all at Millennium Park. And everything else, like Millennium Park has complete control over everything that happens in that property. Those licensees don't really get to make any decisions with respect to how they're allowed to use that space.
I see.
Yeah.
So if you had like a university that owned an office building and one floor, say, were rented out to a for-profit, you know, for-profit business, it's the obligation of the tax-exempt entity, in this case for the university, to declare to IDOR, to the assessor's office, that it has a taxable leasehold on one floor, but then it's the business's obligation of that floor to pay the proportional tax. Is that correct? Property tax.
Right.
Okay.
The ones that I see more of come from Northwestern Medical, like the hospitals. I see a lot more of those come in, and those tend to be taxable. So.
I just wanted to make sure I understood. So for an example, in regard to ground lease and so forth, the Housing Authority of Cook County has a project that is going to go up in what right now is a parking lot. And my understanding, it's the first time ever they've done something like this, where most of the building will be at market or above market rates for rentals.
Okay.
And then some will be subsidized housing.
Okay.
So in terms of taxing, how will that work in that case?
We will look at the entire property. We'll want to know. We will ask those property owners to submit, you know, rent rolls to us so we can see how many units are actually paying market rates, how many are paying, you know, how many are actually subsidized and maybe at a lower income bracket rate. It gets a little bit complicated, but we do have a process for it. You know, with affordable housing or low income housing, there are statutory programs that they can apply for if they meet certain criteria based on the area median income and if they meet certain rent and income thresholds. In those cases, we tend to apply a slightly higher capitalization rate to come up with a market value that is more appropriate for a low-income housing unit. So that is typically how we address that. Otherwise, we would use a market capitalization rate to capitalize income and come up with a market value for units that are market rate units. That's a great question. You can go if you want to go all the way to the end. Yeah, that's okay.
Hi.
So email is usually the best way, but you can call me too.
Hi. My question is, so if someone has a nonprofit organization and wants to acquire property or build a property that's not currently designated as tax exempt,
Okay.
what is the procedure in order to make the property tax exempt?
You have to go through that application. Like if you have a space and say you're adding a new building to an existing PIN. A lot of times the best way to do that is to decide whether or not you want to consolidate into a single PIN or maybe divide into 2 PINs. And then you'd want to go and apply for the exemption anew at the Cook County Board of Review so you can get a letter that covers the correct PIN or PINs. I think that might be the easiest way to answer that question.
And that's only if there's already an existing PIN.
If there's an existing PIN, you can either divide it or you can consolidate it into a new one that would cover the new structure in addition to the original structure that was already there under that original PIN. A lot of times it's easier that way because then all we have to do is assess 1 PIN or assess 2 PINs that are very clearly identify what the boundaries are. If it's one building and another building, it's easier for us to come up with a market value for PINs as opposed to let's carve out a little space of a single PIN just because it's new. But we wouldn't do that though, because to us that constitutes a change in use because it's new. It's a new improvement on the property that the Illinois Department of Revenue never had an opportunity to consider and decide whether or not to grant the exemption for that new structure. So we would tell people they need to go back to IDOR, and get a new letter. And if a division or a consolidation makes sense, we would say you might want to do that too.
And
first.
Do you know typically how long that might take?
It does take a long time. So with the IDOR, just in general, to get an exemption can take anywhere from 6 months to an entire year for IDOR to make a decision from beginning to end. It's a long process. And then if you are consolidating or dividing a PIN, you have to factor in the time that takes too. And that is all based on our assessment schedule in our office because the clerk's office, the Cook County clerk, they're the ones that actually assign new PINs when there is a division or a consolidation. And we have to work off of the assessment schedule. So if, say, you wanted to do that, and there is a time of year where you do have to apply in order for us to create new PINs like that on a division or consolidation. I want to say the end of this month is actually usually our deadline for petitions to consolidate or divide. But I have to double check. I don't remember off the top of my head. But we try to get those in this year so that if we need to create new PINs for the 2024 tax year, that we can tell the clerk's office this is the list of properties that you're going to need to start assigning some new PINs for. It's a very involved process. I don't really do a lot on the division side, but I do review some issues from time to time with that, and I can help you, direct you to the right people.
One last question.
Yes.
And does the process typically, does it have to be once you already have the property?
Excuse me?
Is it do you start the process if you already have the property?
If you mean to divide or consolidate PINs before you get an exemption?
Yes.
If you're going to divide or consolidate a PIN, you will want to be the one that owns the property in order to do it. I have seen people considering whether or not this should be done as part of a transaction so they could sell it to somebody else. But at the end of the day, I think it's whoever's petitioning, we try to honor that petition. And we do request a copy of the deed to make sure that you own the properties that you're asking us to divide or consolidate. So, yeah.
Go back to that slide with the contact information, please. And I have one last question about your request.
Yes, a question about in terms of the exemptions, and I'm just curious if you've encountered this. If someone has a federal trust foundation that owns a property, how is that classified? And have you come across that, specifically federal trust foundations?
I haven't specifically seen anything owned by a federal trust foundation. I don't know what type of organization that is. If it's like a charitable organization of some sort, it sounds like it might be. I don't know. Okay. Yeah, I don't know.
Okay, yeah. Just the distinction between a trust that's under state statutory law versus a trust that's under federal statutory law. So a federal trust foundation. So.
I'm not really sure. I mean, trusts are it depends on what kind of trust it is, I guess, and ultimately whoever the beneficiary is of that trust is going to be the the owner of the title at the end of whenever that at the time of the creation of the trust, and then the trustee will manage it. I don't know that there is a distinction between an Illinois or like a state trust versus a federal trust. I'm not really familiar with that. I haven't heard of it. There are trusts. There's also land trusts and real estate investment trusts. There's multiple different types of trusts under the law. So I'm not really sure, but I'm not familiar with anything called specifically the Federal Trust Foundation. When you said that, I thought immediately, oh, it's a foundation. Maybe it's a nonprofit organization.
It's not a literal entity. It's a class.
Gotcha. I'm not familiar with Federal Trust Foundation as an actual type of trust or legal entity separate from anything else.
Thank you.
Yeah, sorry.
One last question about Northwestern. So they're designing this Ryan Field Stadium. So Northwestern is designing the Ryan Field Stadium to effectively be an entertainment venue. And, who comes to entertain really doesn't matter. Doesn't matter how many times a year. They started at 12, down to 10, down to 6. Doesn't really matter. If it's designed for that purpose, are you saying they have to come back to the Illinois Department of Revenue to have that reviewed as a potential commercial property?
Not necessarily, no.
Why does Northwestern get away with everything?
No. That's not the same though as what I was just describing. It's different. If you're leasing it out, it's based on the lease agreement. You don't have to go and get IDOR to approve a new exemption.
Even if the intent of that building is now, it's not just for football games, which they also profit from greatly, but it's designed to accommodate, they've had consultants who are entertainment experts come to make presentations. So their intent is clear, that's what it's going to be for, whether they get the text amendment or not.
Right, but the ownership of the property still lies with Northwestern.
Correct.
Right, so we wouldn't make them go back to IDOR necessarily. I mean, if they're leasing out space, they're not technically not even required to have disclosed it if it's not something that they had even entered into at the time that they applied for an exemption. They do have to disclose it afterwards, though. I mean, there is an obligation for them to disclose all copies of leases to our office on property that they own that is tax exempt, and that does change the use. And so then it can be assessable if the terms of the agreement are such that would require it to be assessed by our office. But if Northwestern retains ownership of that property, there's no obligation for them to go back to IDOR, unless they build unless there's a new structure that's built and there's question about that, they would have to go and go back to IDOR and say, we need to make sure that this is covered because that new structure is going to get an address. The city of Evanston will assign an address to that property, as all municipalities have to do. And then the county clerk would assign a PIN to that new structure. But we're talking new spaces, new improvements. It's not the same as leasing out space. Yeah.
So to summarize what I think Mike was asking, tell me if I'm wrong, is the design or the material design, at least, of an improvement itself isn't what matters. It's the use of that improvement that matters. It's how it's used in terms of profit. Okay.
Was that a yes?
Correct. Sorry.
So, and in terms of licensing, so say a university builds a stadium and it has smaller structures, are there time restrictions? Like, could you license a small structure to a hot dog vendor for a year and they're commercial, I mean, is there some sort of, I'm just wondering, I can imagine that licensing could be sort of a loophole to get around paying a taxable leasehold. So I'm wondering that. And then my second question is, could a municipality have the right to walk, all of its, in a city, all of it, since nobody is assessing it, to ensure that the use is remaining true to the mission or the charter? Would a municipality have the right to visit tax-exempt properties in a city, since the assessor's office can't really do that? Or it doesn't have,
So we do get from time to time, people will come to either to Fritz or to me or whoever in the office and say, I think somebody is renting out space at that religious institution. I'm pretty sure that no one's paying taxes on it. We'd like you to do something about that. And what we'll do is we will send somebody out from our field team to go and inspect and see and confirm whether or not they're still actually using that property for the exempt purposes for which it was intended to be used for. And if they are, if we find out that they haven't disclosed the lease, we have the discretion to remove their exemption and take it away from them and assess the entire property. We typically don't do that. We usually will try to reach out to whatever contact we have for that exempt property and say, hey, we heard that there's somebody maybe leasing space out. You are required to give us a copy of that. And sometimes people, like reporters or something, will go out and they'll find stuff out and they'll say, hey, I got this lease. I found out that, the blah, 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 whatever. And then we have to, we do something about that usually.
So
But yes.
I'm asking, I've had conversations with the assessor of Haverford.
Okay.
In New Hampshire, they do have a state pilot where universities have to pay for like dormitories, and he said, every year he walks every square foot of Dartmouth, and every year puts property back on the tax rolls. Because it's not just offered up, and you might not know it, but he actually walks. And that's why I'm wondering if a municipality could have that option about legally, if that could be a possibility.
I don't know. I don't see why you can't, go to public property, right? If it's public property. University property is not necessarily public, right? I don't know how you get around. I'm not sure how you get around other laws that might be in place for protecting private property owners. So, yeah, I know.
Okay. Should we, you were going to tell us a little bit about the most
Sure, we
recent,
can really quickly, you want to go back to the Evanston, so I have some numbers just about the 2022 Evanston Township reassessment. Last year 2022 was the triennial year for the north suburbs. The assessed values in Evanston, on the whole, the total increase in assessed value in Evanston went up 28% to $1,495,000,000 total assessed value increase. The portion of AV that was attributable to the residential properties in Evanston rose 27% to $993 million, and then to the non-residential properties, which are the commercial, industrial type properties in Evanston, that assessed value rose to 30%, rose 30% for a total of $502 million. So those are reflections of higher market prices, and then new building activity, which isn't a bad thing. It's a good thing. It typically means some expansion of the tax base, and then. But once the assessor does its numbers, then the property owners have an opportunity to go to the Board of Review, and the Board of Review may reduce a certain percentage of the assessed values on both residential and non-residential side. And after those numbers come out, and after they did come out for 2022 in Evanston, before the Board of Review issued certified their values back to our office, homeowners would have paid approximately 66% of the levy in Evanston. And then after the Board of Review reduced property values for homeowners, the homeowners are scheduled to pay approximately 70% of the levy. So it increased their burden because of the reductions that occurred at the Board of Review. So for every dollar of reduction that the Board of Review granted to residential properties, it granted $4 to non-residential. And that's why it shifts the burden onto the residential homeowners when they make those types of reductions on commercial properties. So that was just on that. I didn't know if you wanted to know a little bit more about generally about the total up the North Tri in general, but I kept this strictly to the Evanston numbers. But Nicole can always answer questions with us about it if you really wanted to hear more about the North Tri outside of Evanston.
How much of the increase in value was due to new construction?
That I don't know. Yeah. She asked if what percentage of that was due to new construction. Did you hear? Okay. Yeah, I was like, I don't know that we have that kind of data. Yeah, nope, we don't have that.
Okay. Any more questions? Okay, here's one. Oops.
So is there a number that you apply to commercial property assessment? I know the commercial properties were assessed a lot higher a couple of years ago, and I think it stayed kind of up there, but it did shoot the commercial taxes up fairly high.
Oh, you're talking about in general?
Yeah.
So, well, first, just to remind you that commercial industrial properties are assessed at 25% of their market value, whereas residential properties are assessed at 10% of their market value.
Oh, okay.
Right. And that's by a county ordinance. The Cook County Board of Commissioners passed an ordinance, the classification ordinance that sets those percentage of market value levels of assessment on property.
Okay, so and then my last question is, so residential single family versus, 2 to 4 units?
Like
or
multi-family, right.
Is there, like if it's 10 or 25% here, is there a difference in those?
Multifamily properties fall within the residential classifications, and so they are assessed at 10% of market value. Yeah, yes.
Okay, well, a big thank you to Christina, Angelina, and Nicole. Thank you so much.
Thank you for having us, and yeah.
So informative. So thank you.
Good.
Thank you all
So
for
glad.
coming on. It's a very important topic for Evanston.
Well, good. Thanks, everybody, for coming out on a Wednesday night.